This is a writ to the United States Supreme Court. The writ is questioning the decision of the Federal Appellate Court in New York, the Second Circuit. The writ involves several prominent people and is clearly an issue that has political overtones and consequences. Hello, my name is Erwin Eisenstein. This program is called Justice in America. It's produced at BCAT, Brooklyn Community Access Television. Today, we're going to talk about a case that I've been working on for approximately 3 years. The case was filed first in the District Court in New York, and then, because the District Court dismissed the action, I decided to take it to the Federal Appellate Court. Again, the Federal Appellate Court questioned certain parts of the action and said that they did not have the jurisdiction to bring some of the parties necessary for the action into a court in New York. What I'd like to do is begin to review the action and show you what's required in order to take an action to the United States Supreme Court. Realize that the Supreme Court really reviews very, very few actions in a year. They probably have between 80 and 100 cases that they review. Approximately 20,000 cases are filed each year with the United States Supreme Court. Approximately 0.5% of all cases that are filed with the United States Supreme Court ever are reviewed by the Supreme Court. Even though you may have a valid action, unless you can get a court of competent jurisdiction to hear the action, effectively there is no justice in this country. With this action, I'm really lucky because the only thing that I've spent is time and not really that much money. And I'd like to go over the process of how you appeal a case from the Federal Appellate Court to the United States Supreme Court. Now, during the course of this, I'll review parts of the action, but more importantly, I'll go over the format of the brief that's required, whether you're going to file it as a poor person, that's called in forma pauperis, or whether you're going to have to pay to have the brief printed by a professional printer and, in fact, have a lawyer review it, and also what the filing fee. Currently, the filing fee in order to file to ask the United States Supreme Court to hear an action, if you're not a poor person, is $300. The $300 is just the filing fee. It doesn't include any mailing or printing costs related to the action. Okay, now what I did is I filed a brief in the United States Supreme Court, and there's a specific format. I'm not sure if this is a perfect format, but let me just give you an idea. First of all, it has to be a certain size, and the Supreme Court will send a package to you specifying the size. Now realize that the size is very specific. It has to be about 6 inches by 9 inches long, and it tells you that you have to have margins of approximately 1 inch on each side and in top and bottom. But more importantly, the first thing you do is you have an introduction. An introduction is usually about a paragraph. It outlines what the cause of action is. The second part that you usually have to have is questions presented. Questions presented are questions of law and questions of fact that you want the highest court to review. Now, even though you're right, they don't always hear these types of actions, and the reason is that it's an area of law that hasn't been questioned in more than one state, so there's no conflict in law between the different states. There are political issues that obviously they believe should be left until they're considered ripe. Ripe is when they believe enough people are involved and complaining about an issue to bring it and to have them make a decision. So even though the Supreme Court can make a decision, some of the things that happen are because of the specifics of any individual case. Federal appellate courts don't always have to follow that decision, and they can do something called distinguish. Distinguish says, well, we understand that the Supreme Court has, arranged these 6 angels on the head of a pin, but our angels are only standing on 1 foot. So our case is different. It's distinguishable from the way the U.S. Supreme Court has decided a case, and we're going to decide a case differently. Okay, so obviously you have to have a cover. The cover is on a paper that's cardboard-like, but it's not very heavy. Again, the size of the brief is 9 by 6 approximately, maybe 9 1/4 by 6 1/8, but that really doesn't make a difference. You have an introduction. The introduction defines the type of action that you're bringing. In my case, I was questioning a particular statute and whether in fact there was an error in the interpretation of a statute by a lower court, the federal appellate court. Then you have questions presented. And the questions presented are outlining the issue of law that you'd like the U.S. Supreme Court to review. My area that I'm questioning is the extent of the Commerce Clause. When can the Commerce Clause be used in my action? I'm going to read from a copy of the United States Constitution, and the Constitution is relatively small. There aren't that many pages, and you can probably read it in about a half hour to an hour. The interesting issue with the United States Constitution is it allows for an extreme amount of interpretation and flexibility. Now, the Commerce Clause is Article 1, Section 8, Paragraph 3, and all it says is to regulate commerce with foreign nations and among the several states and with the Indian tribes. Now, there have been decisions related to that Commerce Clause that are 20, 30, 40 pages, and the 2 most recent that I know of, although there may be others that are relevant, one was called Lopez and the other was called Morrison. Now, both of them are related to acts of Congress and whether the Supreme Court found that acts of the United States Congress exceeded the authority under the Commerce Clause. In any case, I also question whether the Commerce Clause should have been applied in my action and whether it should have allowed me to bring in several parties from other states who I believe are functioning in New York State in some capacity. I believe that it should have allowed me to bring them here, and there was personal jurisdiction based upon the Commerce Clause. So again, you first had the introduction. After the introduction, you have the questions presented. It's a good idea to limit the questions presented to 2 or 3 questions, and in the questions you try to summarize the issues that are going to be raised by the questions, the issues of law and the issues of fact that are involved in the particular decision. Okay, after the questions presented, you usually have parties to the proceeding. So it identifies all of the parties who are named in the action in the lower courts. After that, you have a table of contents. Table of contents basically has each of the major headings and subheadings in the brief. and this is called a brief. And the brief, again, is a small book. I think it's limited to 30 pages. You have to print it on both sides of the page, and it doesn't include the table of contents or something called the table of authorities or the index. So the first part of the brief are free in the sense that they're not part of what you want to present. They're just telling the court what cases you're going to use as a reference, and that's included in the table of authorities, and I'll go a little more into the table of authorities in a moment. But in the table of contents, it really gives a summary of the issues that you're going to present. And what I'll do is I'll go over some of the issues. In my action, you have to clearly say what the opinion below was. You then have to say what the issues are. And in my case, it was subject matter and personal jurisdiction exist based upon the court's Commerce Clause decisions and the False Claims Act. Now that's a summary, and again, you have to have a statement of the case, a summary of the case, and then reasons for granting certiorari to the petition. Certiorari says that the Supreme Court will hear your action based upon what you present in this brief. Now it's very hard. Again, only 0.5% of cases are heard. Very few of them are heard that have been presented by non-attorneys. You usually have major headings, and I say argument 1, argument 2, argument 3, and each one of them summarizes the arguments that you're going to present to the court. Now, what you want to do in these arguments in the table of contents is summarize the issues. And let me just read argument 1. The court erred by saying that an expert opinion and the corresponding analysis is common knowledge, and plaintiff was not an original source of the analyzed information. Now, in the action that I brought to the lower courts, I am an expert in computers and computer systems, and one of the issues in the action is the lower court made a decision saying that I didn't know what I was talking about, and yet I raised the action based on computer programs and computer systems, and matches are when you compare two different sets of information and say it appears that information on one set of information matches information on another set. An example of that is if you match the name or the social security number of a bank statement with the social security number on your income tax forms that you file, usually the federal government, the Bureau of Income Tax, the IRS, will say, hey, we have a match, therefore this income came for this party. Now, in many databases that are maintained by state and city governments, you have information used to identify a person. The person, for example, can be identified by last name, can be identified by first name. Now, these methods of identifying are on several different databases. Databases are a source of information related to a specific area. For example, there's a database of people who live in Brooklyn. And on this database of people who live in Brooklyn, it's likely that you'll have the person's name, first name and last name. You may have the person's social security number. You may have the person's age. You might have the person's street address, and that would be broken into, again, the street number, the street name, the apartment number, and so forth. Now, if you have, let's say, a database of child support, and child support is an area where the federal government requires the states to maintain a database about the children and the parents, and the database must have the child's age or the children's age, must have the child's name, the address, and frequently the social security number of at least one of the parties in the action. It has the address and again the names. Now, surprisingly enough, most states also have information related to children in another database. And that database is a database of school records. Now, usually it's maintained by cities or by the states, and that also has information related to a child. Now, why do I bring this up? I bring this up because many states don't match these two databases. And you might say, well, what's the importance of matching these databases? Okay, let me tell you what the importance is. The importance is when a child graduates from high school in many states, and usually I'll give a number, about 36 states say that when a child graduates from high school and is above 18 but before 19, in other words, he hasn't yet reached his 19th birthday, and he graduates from high school, that child is considered an adult, and the person who's paying child support should stop paying child support. If the person decides to continue paying child support, it's a matter only for that person, and it's optional, but it's not required by 36 states at this point. And that's fine, and it's really a relatively simple computer match. You would take kids who graduate from high school or expected to graduate, and you would match it. And based upon that, you would send a letter out saying, guess what? Child has graduated from high school, and you're not going to collect, or not going to have to pay child support anymore. Now, what's the significance of that? The federal government pays states a bonus based upon the amount of child support that they collect. When they collect, let's say, $1,000, it gets $60 for collecting it. They get 6% of the amount collected. The longer they continue to collect child support, the longer they continue to collect this bonus amount. Now, one of the issues that I raised was there are many different matches that can be made that would help identify cases where child support should be terminated. These cases are not, and the matches are not being run. Now, my position is they're not being run because the states continue to collect money until someone goes to court, has to file the papers, and has the child support terminated. But if you're living in a different state, it's not always easy to go to court, so they'll either build up arrears of money that you're going to owe, or alternatively, they'll have another state where you are living and working garnish your wages and continue to send the money to them, even though the child is no longer eligible to collect this money. Now, why isn't it stopped automatically? My position is it's not stopped because the states continue to collect money, bonus money, fraudulently. And the companies who advise the states on terminating don't tell them they have to do a match to terminate this collection of child support so that they're not defrauding the federal government by getting bonuses based upon the amount that they collect, and also bonuses for administering this program. In other words, they have computer programs and they're getting paid by the federal government between 80 and 90% of the costs of maintaining and running these computer systems, and yet they don't do these simple matches. Okay, that's one of the causes of action and one of the reasons that I'm bringing this action. I'm a computer expert, but it doesn't take a computer expert to suggest that states and counties and city governments are not terminating child support because it's not in their interest. I'd like to raise some of the other issues that I raised the claim about. I indicated, number one, that they don't consider economies of scale. What they also don't do, and I'll just read this, is they say you owe money for past child support that you didn't pay. They put you in a condition called arrears. Arrears says not only do you have to pay now, but you have to pay for what we believe you should have paid in the past. Now that's fine, and what happens though is there's no mechanism in many states to automatically terminate the arrears. So what they do is they continue to collect that extra amount even though you've already paid all of it off. Now realize what happens here. If you were doing business with a bank that had computerized records and were held accountable, the bank would say, well, we are going to collect $10 a week until you pay the amount that you owe. And if it were, let's say, $200 that you owed because you didn't pay in the past, the bank would say, okay, we're going to collect $10 a week, and if you divide the $10 into 200, that would be 20 weeks. And after 20 weeks, they would say, okay, we've collected all the arrears that we had to collect, and therefore we're going to stop. Now, they may charge you interest, or maybe 21 weeks or 22 weeks, but they would stop. Now, in New Jersey, they don't have any mechanism to automatically terminate arrears. So when they say you owe it forever. You have to bring an action to court at taxpayer expense, because every time you bring an action, someone is going to have to hear it, and usually it's a judge. You may have to pay to mail to tell the other party you're going to want to reduce the arrears, and all of this costs money and costs time when it should automatically be stopped. Now, I can't believe that the judges in New Jersey allow this to happen, and yet they do. They do it knowingly. I've been in certain courts. Well, it's happened to me, so that's why I say I believe it's outrageous. And as far as I'm concerned, when judges do this, they should be held criminally accountable. I could have taken about 3 to 4 hours going over the brief. I recognize that there are limits, and therefore I just raised one argument. Each of the other arguments is also, I believe, valid and shows the corruption within the system and the need for reform. Not only does it show the need for reform, it shows that our federal government is reimbursing counties, states, and private actors who are fraudulently submitting claims, failing to terminate child support, and the result of all this is we, the taxpayers, are paying at least $90 to $150 million a year in excess of bonuses and claims. To me, that's outrageous. In the brief, and again, there are a whole bunch of different economic factors like that, and I could probably read them, but first let me just say, after you give all of your arguments, and there are a whole bunch of them, what you do is you give a conclusion. And the conclusion is very, very short. It says, based upon the foregoing analysis, the judgment of, in whatever court you're trying to appeal, should be reversed, and it should be remanded to that court so they can review it again. And then you just sign it. The writ of cert or certiorari should be granted, respectfully submitted, and you give your name. And that's the format. And I think what I should do is give some of the issues that I raised. And again, the court said in my case that I couldn't bring a party in from another state because there was an issue of jurisdiction. And I said fraud is being committed in New York State because when a child support amount is collected in New York, New York is getting the benefit and gets a bonus for collecting for the other state. So New York submits the bonus to the federal government. New York is paid an amount that's excessive also. So it's not only the state that allocated or said, you owe child support, but also New York, where the state said, hey, can you collect this amount for us, New York, because we are telling you that we're correct. And New York usually does it based upon something called full faith and credit, another part of our United States Constitution. Even though it may be wrong, New York would say, well, you have to argue it there. And therefore, there are issues related to whether you can bring the false claim based upon New York collecting, and the fraud occurring based upon the submission to the government of an amount by New York and saying, give us a bonus, give us reimbursements. Okay, and that's basically, the format of the brief. But the brief is an interesting thing. Very few of them are granted. I realize there are about between 15 and 20,000 submitted a year. Approximately 80 to 100 cases are heard. Most of those cases are heard based upon large issues, corporations who want to raise a specific issue. There are sometimes very small cases, and the reason sometimes small cases is that it doesn't impact a large number of people. For example, death penalty cases. Sometimes death penalty cases can impact just 1 or 2 people, sometimes maybe 100 or 200 people, but it's not where it impacts thousands and thousands. This is Justice in America, and I produce a show in Brooklyn for Brooklyn Community Access Television, and I'd like to thank all of the people there who've assisted me in producing this show. Thank you.
Well, I said that. I also said, in fact, I said.